Welcome back to another explainer. Today, we are meticulously breaking down a true landmark in criminal jurisprudence, T.T. Antony versus State of Kerala, 2001, 6 SEC 181. Now, if you're a focused learner, maybe a law student looking to deeply understand the absolute limits of police power, or just exactly how criminal investigations legally commence, well, you are in the exact right place. We're going to unpack what's known as the doctrine of the singular FIR. And to make sure this is crystal clear for your notes, we'll be using an enhanced IRAC method. Issue, rule, application, and conclusion. Okay, let's dive into this. Here's how we're structuring today's brief. We'll start with the facts of the case, isolate that core legal issue, map out the relevant statutes, look at the clash of legal arguments, explain the sameness test, and finally wrap up with the landmark judgment. All right, setting the stage with part one, the high-stakes factual scenario that started it all. Picture this. It's November of 1994. A state minister arrives to inaugurate a cooperative bank in Kerala. But this triggers intense, volatile protests from a rival political faction. The demonstrations quickly escalate into violent rioting, and the police open fire to contain the crowd. Tragically, 5 protesters are killed and several others are severely injured. Right after this, the police filed 2 first information reports, crime numbers 353 and 354, charging the protesters with unlawful assembly and attempted murder. But then, post-1994, the political landscape shifts. The state government changes hands. A judicial commission of inquiry is set up to look into the incident, and they come back with a bombshell. They conclude the police firing wasn't crowd control. It was actually an unprovoked, excessive use of force orchestrated through a deliberate conspiracy. Armed with this new report, the executive authorities order a fresh investigation. So in 1997, the police file a third FIR, crime number 268 of 1997. But this time, they are naming the police officers themselves, including the then superintendent of police, T.T. Antony, charging them with criminal conspiracy and murder. Obviously, Antony and his officers challenge the subsequent FIR. They argue it's a complete abusive process, and this massive fight goes all the way to the Supreme Court. That brings us to part 2. Let's separate the dramatic facts from the precise procedural roadblock.
The absolute core legal question before the Supreme Court is this: can the police legally register a second or subsequent FIR for the exact same cognizable offense or occurrence and sustain an independent, parallel investigation? This is the crux of the problem right here. It's a massive tug-of-war. On one side, you have the need to prevent the abusive police process, and on the other, the absolute duty to uncover the truth of a state conspiracy.
Moving to part 3. To really grasp this, we absolutely have to map out the rules. Now, what's really interesting about this is how the structural sequence of an investigation maps out under Chapter 12 of the 1973 Code of Criminal Procedure, right alongside the brand new 2023 BNSS. Pay close attention to that first step. Section 154 or Section 173 in the new code is the registration of the FIR. Think of this as a literal gate. Once that gate is opened by an information disclosing a cognizable offense, the criminal justice machinery is in motion. You then move down into the investigation phase with Sections 156 and 157. You record witness statements under Sections 161 and 162, and it all ultimately leads to the submission of the final report in Section 173. The entire debate in T.T. Antony hinges entirely on that first step. Once that gate is opened for a specific incident, does the law literally allow you to build a completely separate second gate for the exact same incident? Let's move into the application phase with Part 4, the clash of the legal arguments. The appellants, the police officers, are arguing strictly on procedure. They contend that under the code, an FIR is simply the trigger mechanism. Once an investigation begins into an incident, any further information or even counter-allegations absolutely cannot form the basis of a brand new FIR. They warned that if you treat every new version of an event as a separate FIR, you were exposing citizens to endless, repetitive investigations based on political whims. It completely violates due process. But on the flip side, the respondent, the state of Kerala, faced a very real dilemma. They argued this second FIR was absolutely essential. Why? Because they uncovered a completely different offense, a deep-rooted state conspiracy to murder protesters. They said, look, the original FIRs only looked at the rioting mob. This new FIR targets murder committed by the police with completely different accused persons. We are duty-bound to register a fresh case.
So how did the Supreme Court untangle this? That's part 5, the reasoning of the court. So
The crucial point is the application of what is globally known as the sameness test, or the single transaction test. For your notes, this is a legal doctrine stating that any subsequent information received by the police after the registration of the initial FIR, which relates to the same incident or same occurrence, does not have the status of an independent FIR. Going right back to our gate analogy, you cannot build a second gate. The scheme of the code flatly prohibits a police officer from registering multiple FIRs for the same cognizable transaction. Instead, any new facts, subsequent statements, or completely opposite counterclaims, they must simply be treated as witness statements recorded under Section 161. They fall strictly within the ambit of that ongoing original investigation. Justice SSM Quadri and the bench were incredibly sharp in their critique of the state's actions here. The judgment explicitly states if a second FIR were permitted, it would grant the police an unregulated, arbitrary power, bypassing judicial oversight. The court recognized a massive civil liberties danger. Think about it. If you allow a second FIR every time a new suspect is found, or every time a rival counter-theory is proposed, you essentially hand the executive a tool to keep an investigation alive indefinitely. A mere change in political power or an administrative shift could easily be used to manufacture brand new cases against individuals for old incidents. But the state had a valid point, asking, well, if we can't file a new FIR, how on earth do we prosecute the police for a murder conspiracy? And this brilliantly illustrates the court's elegant solution. It's really quite simple. First, do not file a new FIR. Second, simply expand the scope of your existing 1994 investigation. Third, add the relevant Indian Penal Code sections for the newly discovered crimes of murder and conspiracy to that original file. Fourth, name the newly discovered perpetrators, the police officers, as the accused. And finally, submit all of this consolidated evidence in a single final report to the magistrate. This gives the state exactly what it needs to pursue justice, but without breaking the structural sequence of the criminal code. Which brings us to our conclusion, Part 6, Resolving T.T. Antony. Applying the sameness test, the Supreme Court allowed the appeal and firmly quashed that subsequent FIR, crime number 268 of 1997. Along with literally all the investigative steps taken under it. They established the unshakable rule that there can only be one historic foundation for a single criminal occurrence. However, to ensure that justice wasn't totally defeated by a procedural technicality, the court made a highly pragmatic move. They directed that all the statements, the evidence, and the materials collected during that illegal second investigation be officially transferred and treated as part of the ongoing investigation of the original 1994 FIRs.